Hi, everybody. My name is Sharon Smoot. I am a realtor with Coldwell Banker, and today I'm here with attorney Ebony Phillips, and we are going to be discussing some of the most common issues in DUI law. I have known Ebony for, what, 10 or 12, 13 years, something like that?
At least.
We first met while I was still practicing law. I used to do real estate closings. I had a solo practice, and I handled Ebony's closing. And we met again a few years later when I ended up renting office space in the same office where Ebony rented office space. So we're going to go ahead and get started. Ebony is first going to tell us a little bit about her background. So why don't we start by you sharing with us how long you've been practicing law?
Sharon, I have been practicing law, I think this is year 17. I was admitted to the bar in 1998, so I think that's about right, about 17 years. Yep.
Well, I didn't realize that it had been that long.
It's been a minute.
Wow.
It's been a minute.
Time goes by way too fast.
20 years will be here before I know it.
And where did you work prior to starting your own practice?
I had a couple different jobs, but immediately prior to starting Phillips Law Group, I was a prosecutor actually for the city of Atlanta in Fulton County. And believe it or not, I prosecuted mainly DUI cases and traffic cases and vehicular homicides and things like that. So I was fortunate enough to get that experience and then ended up starting my own practice right after that.
Okay, and what year did you start your practice?
That was 2004.
Okay.
So I've had my own practice for about 11 years now.
Cool.
Mm-hmm.
So I guess you really get DUIs from the prosecutor's viewpoint.
Absolutely, absolutely.
So I guess that can be of real benefit to your clients.
I think so. I think one of the things that I really, really stress to my clients is that I get to see the case from both sides. I know what a prosecutor is looking for in terms of trying to obtain a conviction. I know what they consider to be a good case. I know what they consider to be a not so good case. And I know what they consider to be a case that they're going to go, strongly to bat for. And then having been doing defense work now for a while, I know sort of how to balance those two interests. And so I think that gives my clients an advantage.
Okay. Well, why don't we start by discussing the typical scenario for a DUI traffic stop?
Okay, so let me just say this before we get too far into this. I want to just stress to everybody that while I think you're going to get some good information during this session, this is not by any stretch a substitute for legal advice regarding your particular case. It's not intended to be legal advice. And certainly the viewing of this interview does not create in and of itself an attorney-client relationship between myself or my firm. But to the topic of the typical DUI stop, what we see most often, you're going to have two main categories. You will have a traffic stop where you come upon a roadblock. That's what they call a sobriety or checkpoint or a driver's checkpoint. And the officers are going to be pretty much stopping everybody at that point. So at that point, you really haven't been singled out necessarily for anything that you've done in particular, but you are being stopped because everybody's being stopped. And then that'll usually lead itself to a traffic investigation if the officer sort of thinks that you need some further evaluation. The other primary one, though, is the typical traffic stop that goes awry. Either you blew through a red light or didn't stop at a stop sign, or you're speeding, and what starts out to be just, let me write this person a citation for a traffic infraction. Somewhere along the way, somewhere in that interaction, the officer decides that there is more to the situation and will ask you questions like, have you had anything to drink tonight? Where you had it? Where are you coming from? Those types of things.
Now, let me ask you a question. If the officer starts asking those types of questions, is the driver required to answer?
So that's sort of a tricky question, because the officer at that point is not asking anything that really is on its face incriminating, let's say. So it is usually in the driver's best interest at that point to be cooperative and to answer those sort of what we call benign kinds of questions. But as a citizen, you do have a right to not answer. Understanding, though, that when you choose not to answer, there may be some consequences and repercussions to that, because if the officer has already decided that, based on their suspicion that you're DUI, that you should go ahead and be arrested, that, that might happen at that time. But by all means, you do have a constitutional right at all times to remain silent.
Okay. So I interrupted you. You were talking about the second scenario.
So what generally happens if the officer has formed a suspicion, let's say he or she might feel like they smell alcohol about your person. They might feel like your eyes are bloodshot or glassy or something like that, or maybe your speech is a little bit slurred. They're going to be asking you a series of questions. Where are you coming from? Have you had anything to drink? Those kinds of things. And at some point, they're going to ask you, if warranted, to exit your vehicle. When they ask you to exit your vehicle, there's a couple of what we call field sobriety evaluations typically that are done. There are standardized varieties and non-standardized varieties. So the non-standardized ones are things like, can you say your alphabet, without missing letters, or can you count to some number that they predetermine and things like that. But
like a million.
Like a million one. But the standardized ones are prescribed by the National Highway Traffic and Safety Administration. Those of us in the business call it NHTSA. And basically NHTSA has said these are the tests that are to be done only by trained professionals who've actually had the training the same way every single time. They're to be demonstrated the same way, instructed the same way, and carried out the same way. Hence, that's why they're called standardized. Now, if it turns out that you're not doing well on those, or the officer's just not sure, he or she may perform what we call a portable breath test, or a PBT is what we call it for short in the business. And basically that's going to be a portable device about the size that I'm kind of trying to cup here with my hands. It has a disposable mouthpiece on it. They're going to have you empty everything out of your mouth, like if you have gum or candy or something in your mouth. Ask you to blow as hard as you can, as steadily as you can, until they tell you to stop. And that's going to give them a reading of your alcohol concentration. All of these things that I'm describing are what we call going into the probable cause to believe that you're under the influence of alcohol. And if it turns out that the officer has formulated in his or her mind that you are indeed driving under the influence of alcohol based on these evaluations, they're then going to read you what's called implied consent, or the Georgia Implied Consent Notice. And that is a little card that they read that basically tells you that Georgia law requires you to submit to chemical testing of your blood, breath, alcohol, urine, or other bodily substances for the purposes of fully determining whether you're DUI. If you are going to submit to the test, that will happen usually at the jail. That's going to be a totally different scenario than the little portable that we just talked about. They'll sit you in front of the machine at the jail in certain conditions, and it's supposed to be carried out in a certain way. If they ask you to take a blood test and you submit to that, then that's usually going to be at the hospital or some medical facility. That will not be at the jail usually. With the breath test, though, you will get your results instantly. It will print out a card on the spot to say what the reading is.
So let me ask you a question.
Mm-hmm.
The portable breath test that's done out in the field, that's something different than the test that's done at the jail.
It's totally different, because the thinking behind it was, on the roadside, it's not scientific, it's not sterile conditions. There are all these other intervening factors in an uncontrolled environment. So they don't want to necessarily subject someone to a DUI based on that alone. They will take you to the controlled environment with the control machine and all the protocols to run that test on your breath at that particular time. The breath test that you do at the jail is admissible in court, provided that all of the standards are met. The portable breath test, that number, although it will give the officer an indication, because they do get a reading back when they do that, but they're not allowed to say what that number is in court, just because, like I said, it's in an uncontrolled environment. But they will be allowed to testify whether you came back positive or negative for the presence of alcohol in your system. So that's just a little bit differentiation between the roadside and then the scientific approach.
Okay, and then you have been saying if you submit to the various tests. So if they have stopped someone, if the police have stopped someone out on the road,
mm-hmm.
they don't have to submit to the portable breath test?
So the way that it works is that, and we were kind of alluding to rights earlier, you do as a driver have the right to say, I don't want to participate in your test. The field sobriety evaluations are voluntary. The breath test, you could also refuse. Now, keeping in mind, though, that just because you refuse doesn't mean you're in the clear, because the state has decided that it's in their best interest for motorists to agree to be tested if there is a suspicion that they're DUI. So what will happen in that instance is that you will have the ramifications that come along with that. For instance, you have the right to refuse the breath test, but if you do refuse the breath test, you will be subject to a license suspension, automatic, no matter what your test result may or may not have shown, just because the state feels like it's in their best interest for motorists to be tested. With the field sobriety testing, it's a little bit different, and here's my take on that. When motorists are stopped by an officer, you pretty much know what you had to drink that night or that day. You know how much, and you know if you've been affected by alcohol. In large part, in my experience, both as a prosecutor and as a defense attorney, if an officer is asking a motorist to submit to field sobriety testing, let's say, the one leg stand is a standardized test, the walk and turn is another one that they do. It usually is for the purpose of building the case for probable cause to arrest for DUI. Very rarely do I see an officer asking someone to take those tests, you know, the 9-step walk and turn, the one leg stand, and so on. And then they say, oh, okay, you're good to go. You're not impaired. I'm going to let you go home. What generally happens is those tests and the results of those evaluations become part of the file that's used then to prosecute the person for DUI. So I get a question a lot about, should you refuse, should you not refuse, should you take the test, and so on. And this is what I tell people. I believe that if you know that you have not had a drop to drink, and I mean a drop, I don't mean like, okay, I only had one drink or I only had 2 beers. I mean not a drop to drink. Then you may be okay to take the field sobriety evaluations and then to also submit to breath testing and chemical testing and so on. But if you've had anything to drink, probably the only thing that's going to happen when you take the field sobriety evaluations and when you take the breath test is that it's going to go into the file as part of the case against you. So although there are some consequences and penalties administratively, because like I said, you could lose your license if you refuse, you might have a better chance by refusing of beating the DUI case. So it's one of those things where when you come upon an officer or when an officer comes upon you, at least initially, you have more of the facts than that officer does. You know exactly what you had to drink, you know how much, and if you know you've been drinking, it's not always in your best interest to submit to chemical testing that can be used against you later.
Okay, let me ask you this, because when we think of DUI, we're primarily thinking about the consumption of alcohol.
Right.
But can you be charged with DUI for, let's say, marijuana? Or let's say, for instance, that I took an Ambien at 3 o'clock in the morning, knowing that I should be asleep for at least 8 hours, but I have to be at work by 8. Can I be charged with DUI because I've consumed an Ambien and it's impaired my ability
Absolutely.
to drive a car?
So in Georgia, DUI law encompasses alcohol, it encompasses illicit drugs, such as cocaine, marijuana, those kinds of things. It encompasses prescription medication as well. So it's not just limited to, okay, maybe I did take an Ambien, but I didn't have any alcohol. So why are you charging me with DUI? There are alternative methods of charging DUI in the state of Georgia, which actually brings me to my first number one, as we were calling it when we were promoting this session, misconception about DUI law. One of the things that I want people to be very aware of, and I know there's a lot of misconception based on what's seen on the television shows and the internet and those types of things.
I can't trust what's online.
I don't think you can. I don't think you want to, Sharon. I don't think you want to do it. You can trust it for entertainment value, but not for legal purposes.
Okay. And so I shouldn't expect that my DUI case is going to be wrapped up in an hour.
Not unless you're on an episode of CSI.
Okay.
Other than that, you're going to have to wait a little bit. But the thing that I want to share with people, because I do hear this in my DUI consultations, is that a lot of us are aware that the legal limit for alcohol consumption for people 21 and older is 0.08. Here in Georgia, it's lower. for under 21, but let's just, for the simplicity of it, use the adult version of 0.08. There are people who will submit to the state's test and they blow below a 0.08 and they get charged with DUI anyway, and they can't understand it. Well, wait a minute, they said the legal limit was 0.08. Why do I have a DUI charge? Why did I get arrested? And now I have to go to court when I blew under the limit. Georgia allows the police officers and the prosecutors to charge on what we call the alternative, right? And if my grandmother was alive, she'd say, that's how they get you coming and going, right? Mm-hmm. Because what the law has said and what the legislature has decided is at a 0.08, no matter who you are and no matter how well you hold your liquor, we don't want you driving, period, okay? But now there are some of us in the population, I won't call any names, pointing to myself, who are not really drinkers, okay? And so it doesn't take a lot of alcohol to affect us for that reason. So even if somebody who doesn't drink a lot, for instance, and who doesn't hold their liquor well, were to take the test and come back lower, if it's determined that they did have some alcohol before operating a motor vehicle, and it's determined that that alcohol affected their ability to drive safely, that is the foundation for a DUI less safe charge. That's what it's called, DUI less safe. So you are behind the wheel of a car or other vehicle to the extent, excuse me, that you're a less safe driver based on alcohol that you've consumed. You don't have to reach the 0.08 threshold for the prosecution to make out that charge. In the alternative, because remember I said we were talking about charging in the alternative, if you are somebody who is a 0.08, maybe you hold your liquor well, maybe you don't, it doesn't matter. The legislature has decided that that is the threshold that we don't want anybody driving, no matter how well they can operate the vehicle, no matter if they can say their alphabet backwards, no matter if they can count 2,000,001, we don't care. We don't want them driving at a 0.08. So number one, biggest misconception that I see about DUI law, and this is critical for folks to know, is that even if you blow under a 0.08, under the right set of circumstances, you could still be charged and arrested for DUI. That's very, very important.
So let me ask you this in that regard. Let's just say, for instance, that a woman who doesn't drink very often has had one glass of wine and she gets behind the wheel of her car and she runs into her neighbor's mailbox. Would she be charged with a DUI less safe if she blows 0.08 or less than 0.08?
So here's the bad news. Although it's considered to be charging in the alternative, you could actually have both charges at once.
Okay.
So depending on whether or not your neighbor submits to the state's test, if she were to do that and she blow 0.08 or more, that's your DUI per se count, okay? In an abundance of caution though, a lot of prosecutors and police officers will also charge that less safe with that per se count, because after all, she did hit the neighbor's mailbox. So her driving, was effective. Yeah, and it was less safe. So you've got, I've seen accusations, and an accusation is just the state court form of what people know as an indictment in superior court. But I've seen them where they've charged them DUI less safe, DUI per se, DUI drugs, and then there's even a count for DUI combination. So you could have multiple DUI counts in a single accusation, which is something that your neighbor might be, like the lady that hit the neighbor's mailbox might definitely be looking at.
Okay, wow.
Yeah.
And so what are the possible penalties for someone convicted of DUI?
All right. So for DUI cases that either are pled guilty or there's a conviction obtained, you have a couple things that you're going to be facing. The more obvious one, obviously, is jail. I think people are very familiar with that. You could also be facing community service, DUI school you're going to have. Some judges are requiring drug and alcohol evaluations, AA meetings. Probation is required by the statute, so you're going to have some form of monitoring going on. And of course, you're going to have fines. If you're placed on probation, you'll also be subjected to probation fees, and those can be anywhere from an additional $30 to $50 per month, on top of the fine payments that you have to make. And it just depends really, those are sort of like the statutory minimums that I just laid out, but it really just depends on how creative the judge and the prosecutor want to be with your case. It just kind of depends, you know, because I've seen it where if there's a DUI and there are children involved, and when I say children involved, like there's a mom who's driving DUI and her kids are in the back seat, I've seen that person have to take parenting classes for a year. You know, so it just kind of depends on the facts, but those are the mandatory minimums, the things that I just mentioned. But you also need to be aware too, that that's the criminal component of it. The criminal component of your case is going to be, did you violate the laws of the state of Georgia by driving under the influence? There is also what we call an administrative piece to it, and that pertains specifically to your privilege to drive in Georgia. And those cases are running on a parallel track. So it's very important to make sure that you know that, so that in your criminal case, you don't do anything to jeopardize your administrative portion and vice versa. And a lot of times people are not aware, particularly people that don't know about the administrative penalties involved. They're concentrating only on the criminal piece, and they don't know about the administrative piece. And when they realize it, it's kind of too late because those things are time sensitive.
And Attorney Phillips, isn't it also true that if there's any type of property damage or bodily harm, that there may also be civil penalties?
Absolutely. That's a great point, Sharon. The thing that you have to be aware of is that if you have an accident, either you ram into another car or you ram into a mailbox. I've seen people even run into streetlights and stuff like that. There's a restitution factor, first of all, from the criminal piece, right? So if you run into the light post and the light post belongs to the city needs to replace that light post. Guess who gets to pay for that? The person who knocked it over.
And that's true even if you weren't drunk. My mom ran into a telephone pole and had to pay for that.
The city wants their money. Yes. They want their money. So that is the sort of the restitution piece in the criminal sense. But also there's going to be some civil liability as well, potentially, where the person who is what we call the victim of your actions either has some bodily injury, they have wage loss because they weren't able to work for a week because they had to have some medical care and treatment because of the accident that you caused, or they have medical bills. But in large part, these are going to be covered by automobile insurance, but not always. There are times when the automobile insurance is insufficient to cover the losses, and then you have personal liability that may come into play. So that's a great question, Sharon. And that's why you have to be aware, because remember, we're talking about overlapping areas of law. You have the criminal piece from the DUI charge itself. You have the administrative piece from the license part. You have the restitution piece from the property damage, and then you have civil liability potentially from any losses that another person might incur based on your negligence. So there's all these overlapping areas that you really have to be aware of.
Okay, and then one thing that I wanted to ask you before we move on to the second big misconception,
okay,
is, are the penalties stiffer if it's your second or third or fourth?
Absolutely,
DUI?
absolutely. DUI law is no different from what we call general criminal law, in the sense that the first time you commit an offense, you're going to be in a particular category, usually the lowest category of sentencing. If you continue to commit that same crime, every time you do so, the penalties get stiffer. It's the same thing with DUI law, up until a point where if you continue to get DUIs, you might be subjected to what we call a habitual violator revocation. And basically what that means is it then becomes a felony for you to drive a vehicle. But that's for people who have, you know, obviously lots of DUIs. But you're absolutely right. The more DUIs you get, the more community service you have to do, the more jail time you're looking at, the longer the length of the license suspension, the longer the length of the probation. Judges might even require intensive in-house treatment, which is very expensive. As part of your probation, if they see that really you do have a drinking problem and it wasn't just a bad judgment on a one-time basis.
So let's talk a little bit about the second biggest misconception.
Okay.
You want to tell us what that is? So
we were talking before about people not being aware that even if you blow under the limit of the 0.08 that the law has established, that you could still be charged with DUI. And I think sort of to dovetail that, the other thing that I would want people to know, sort of in that same regard, is that even if you blow over a .08, in my estimation and in my experience, it doesn't mean that you should just automatically go in the court and plead guilty or go in and accept the prosecution's offer. I think even though you are over the legal limit as a starting point, that there are other options available. And so you shouldn't just automatically plead guilty. I have a lot of people who come to see me and they've blown over the limit and they say, you know, I know I'm going to have to plead guilty because I blew over the limit. I just want to know what I should expect. And I say to them, well, what do you mean you know you're going to have to plead guilty? And they say, well, I was over, you know, .08. I was .16. That's twice the legal limit. So I know I need to plead guilty to it. I don't have any choice. And I would say that that's the second biggest misconception by far, because DUI is a very technical area of law. So there are choices available. So don't just automatically think that because you blew over the legal limit, you should automatically go in and plead guilty or just automatically accept what the prosecution is offering in terms of a sentence. That's my big number two, I think.
So let's say, for instance, that a person comes to you and they've been charged with DUI, they blew over .08. And in investigating the case, you learned that the officer that stopped them had not been trained in the standard field sobriety testing. Would that be a basis for challenging the DUI?
Oh, absolutely. One of the things that I tell people is that just because you have been charged with a crime, the prosecution still has to prove it. They still have to prove your guilt beyond a reasonable doubt. And the way that they do that is by presenting evidence, but evidence that is not going to be admitted at trial is not going to be able to be used by them. So one of the technicalities of DUI law, we were talking a little bit ago about the scenario of the typical traffic stop. When you get stopped by the police and they do these certain things, they ask you these certain questions on and so on. One of the things that people need to know is that those encounters are not supposed to be conducted in a random manner. The tests that they give you are supposed to be done in a certain way. The instructions are supposed to be given in a certain way. The demonstration, also the evaluation, and even the scoring, they're supposed to be scored in a certain manner. The order in which they give the test matters. The things that they say to you or are not allowed to say to you during their encounter matters. When they read the implied consent notice that I talked about, there's a certain time they're supposed to read that. They can't read it too soon, they can't read it too late, or their test might not come in. It is very important for folks to understand that although it looks a certain way, because the end result is, and I know that's sort of what you're going to be looking at, well, what did I blow? Or what was my breath test? What was my blood test result? But the reality is that they can only present that to a judge or a jury if everything leading up to that is done in the proper way. And so we file challenges to their evidence all the time. And it may be a situation where we are able to get the breath test suppressed, but the field sobrieties come in. But that still gives us a better chance of success rather than have everything come in. Or it could be a situation where everything was so poorly done so early on that the judge says, I don't trust any of this case. I'm going to throw out the field sobrieties and the breath test. That we're in great shape at that point. So there are challenges that can be made to their evidence. We do it either by motions in limine, is what we call them, or motions to suppress their evidence. But just to give them a rubber stamp because you blew over the limit, and I'm not saying every case can be won this way. I don't want to be misleading. And I'm not saying that every suppression motion that we would file, we would be successful on, but I am saying that people need to know that there are options available. A lot of people feel like if I blew over the limit, I'm toast. There's nothing I can do. But there are options available through the legal system. As a defendant, you have rights, and the prosecution also has burden. They have to prove your guilt beyond a reasonable doubt. And if they can't do that, either because some of their evidence got thrown out or their officer didn't conduct themselves in the right way, then we're going to be there to pounce on that.
Well, I mean, it sounds really complicated and time consuming. So why would someone even go to all that trouble? And especially someone who is a first-time offender?
You know, what I would say to that, Sharon, is that you're right. DUI is complicated law. It is very technical. It's a lot more technical, I think, than a lot of aspects of general criminal law. Mm-hmm. So I get that. But the reality is that it is also one of those offenses that has a stigma associated with it. When you have to tell your boss you've been convicted of DUI and wonder whether or not they're going to keep you on. When you have to answer yes on a job application and wonder if that's going to keep you from getting an offer. When you have to go home or tell your husband or wife, you know, you've gotten a DUI, those stigmas stay with you. And that is one of the things in our society that is really hard to repair. Your reputation in the community, in your church, and whatever groups that you belong to, on your job, and even with your family. So that's one part of it. Obviously, you want to fight the fight if you're facing jail time. I mean, nobody wants to lose their freedom if they don't have to, particularly if there's a way around it legally. You want to do that. But I think there are financial ramifications as well. Somebody said the other day, and I don't know if this is accurate or not, so I repeat it with a grain of salt, but I read somewhere the other day that nowadays the sum total of all the losses that you might accrue from having a DUI on your record or something like that, the first total is going to be $10,000. That's going to be all your fines and the jail time, so the job loss or the time from work and stuff like that. But later on down the road, it's going to come back again probably, because the reality is that on a job application or an application for school, whether it be grad school or undergraduate institutions, they're not going to say, have you been, and your DUI could have been 10 years ago. They don't normally say, have you been convicted of DUI in the last 5 or 10 years? The question usually is phrased as, have you ever? Have you ever? And to answer honestly, you have to say yes. You know, so while you might not necessarily feel like at this juncture in your life a DUI is fatal to some things that you're trying to do, 10, 15 years down the road, you might find yourself in a different position and have a DUI conviction holding you back when there may have been options to keep it from being on your record in the first place.
And I guess the ramifications are even bigger for someone who drives for a living,
Absolutely.
a trucker or
Absolutely.
delivery man or whatever.
You know, I have people who actually are on the brink of divorce because of a DUI.
Wow.
It has just such a stigma to it, and they have certain positions in their church, for instance, and so they don't want to be the spouse is not trying to be associated with somebody who has that kind of a negative stigma. Now, I don't say that everybody responds that way, but there are people who feel like if the person has, for instance, been arrested and they have to bond them out, then that has put their marriage in a totally different place, and it's hard for them to come back from it. So whatever we can do to preserve a person's livelihood, their home life, their job, their station in life, their community situation, we're going to do that, because at the end of the day, none of us are perfect, right? And we all find ourselves in situations that we probably would rather not be in based on a judgment call that we made or didn't make, as it were. But that's part of what we do to seek justice in a way for people. Because even if you feel like the person is guilty or not, I mean, you know, that's always up for debate, right? That's why we have trials. The reality is that they still have rights. They still have a right to a zealous defense, to a vigorous defense. And that's what we try to provide for them.
Wow. This is some really good information.
Well, thank you for saying that.
What kind of trends are you seeing in DUI law?
If I had to think about it in terms of trends, I think what's standing out right now is, and this kind of, I guess, dovetails to what we were just talking about, is that there was a time where you kind of knew if you were going to have a DUI conviction on your record, or you're going to plead guilty or anything like that, you were going to have certain ramifications, and that was going to be, you know, kind of where that was going to be, particularly if, as you mentioned a moment ago, you wanted to drive for a living, whether you wanted to be a CDL driver, a package car driver, a courier, somebody who's a pharmaceutical sales rep, all those folks who drive for a company, they were going to pull your record and see if you have any bad driving, and in particular DUI. What we're seeing more now, though, is that a wider range of employers are looking at driving histories, even if the employer is not going to be driving as a part of their job. So they want to know if the bookkeeper has a DUI, if the secretary has a DUI, if the mail clerk has a DUI, because it seems that they're associating the judgment to drink and drive, or the decision to drink and drive, excuse me, as sort of an indicator of what kind of decision maker they are. and what their thought process typically is, and if that's going to be a good fit within their institution. We kind of see it a little bit also with, just to give you an example of kind of what I mean, there was a time where you knew if you were the cashier or the bank teller or the bookkeeper or the person who deposited the money at the end of the day, they were going to be looking at your credit report. They want to know if you have any money problems that might encourage you to move a decimal point, let's say, or to not take everything that was in the deposit bucket to the bank. But now what we're seeing is they're doing that across the board more. So it's not even just people that are going to be handling money or responsible for accounting of funds or any kind of fiduciary responsibility whatsoever. The same example that I just gave, if you are the secretary or the mail clerk or whoever, they're looking at your credit report to judge if you are a good decision maker, if they consider you responsible, if you are the type of person that makes the kinds of decisions that they think are a good fit with their firm. So in terms of a trend, I think I would say the consequences of DUI probably are more far-reaching now than they ever have been before, especially from an employment perspective. I think we also see it a little bit more now, more strictly applied when people are applying to different schools. I think it probably was already looked at before, but it seems now it is used more often to eliminate people from undergraduate and grad school for that matter. So I think if I had to just identify a trend, just kind of like off the top of my head, I think that's what it would be.
And so really the lesson there is that the consequences can be very, very far reaching.
Oh,
years
absolutely.
into your life. I mean, you could be 55 and applying for a job.
Absolutely.
Or you've decided to go back to school, and that DUI you got back when you were 21
absolutely
could prevent you from getting into school or whatever.
Right, and that's what we want to stress to people, to look beyond this particular moment in time, because all of us are going to live more than the 6 months that it takes to process this case through the system. And you might look back later and say, you know what, maybe I should have fought that DUI because I'm having to answer yes on this application every time and I'm getting turned down, So you don't want to be one of the people that probably had a chance to fight and chose not to fight or challenge their case, as it were, and, have to live with that kind of a regret.
Now, before we got started, I checked to see if anyone had posted any questions.
Okay.
And there was one question that I find a little bit compelling, and it is, can you be charged with DUI because you've recently consumed mouthwash or a breath mint?
I'm laughing, not at the question per se, but I just pictured in my head a cartoon blurb of somebody drinking mouthwash, and that's totally like an aside. I'm sorry about that. But the answer is, it depends. And I hate to answer it that way, but the reality is that there are certain alcohols that will show up on a breath test, right? And so
I love me some Listerine.
Well, be careful, Sharon. Be careful. And there are certain challenges that have been made to breath test results actually because of what people feel to be the machine's failure to differentiate between the different kinds of alcohols, which is again what I'm talking about when I say challenges to your 0.08 case and to your DUI case, because if there are non-compliant issues, like the test wasn't done in such a manner to differentiate between those different mouth out, or another one that we get is like different people work in the construction industry, and so they may have certain aerosols that register as alcohol in their so you or diabetics, their blood processes sugar and alcohols differently than than other people's. But if you don't know that you can challenge those things, you see that 0.166 and you say, oh, okay, I've got to plead guilty to it.
That really raises another question. When someone comes into you and they've been charged with DUI, do you ask them about their health?
I do.
They have diabetes.
I do.
So interesting.
I do. The other thing that could trigger some false positives is certain low carb
products, like
or like if you have a person who's fasting and things like that.
Wow.
Their body starts. Some people's body processes all of that. So there's, when I tell you dozens of challenges you can make, there's literally dozens under the right circumstances that you can make. Wow. Yeah, but I do ask about their health, what they have, what kind of work they do, to see what they've been exposed to, that they may have ingested, if they were fasting or any kind of fasting program. You just never know what's available until you really get into the consult and figure out what the client's particular situation is. But we're always looking for challenges, because at the end of the day, the police do a good job in large part, and they have a tough job to do, but they're not perfect. None of us are. So to the extent that there have been mistakes made, to quote my grandma again, she would say, "Tie goes to the runner." So tie goes to the runner. Yeah. And she used to say that about everything, though, not about baseball, just about anything in life. Tie goes to the runner. And I thought, well, okay, I guess I'll use that, Granny. But that's kind of how it's designed to be, because remember, it really is innocent until proven guilty. So the defendant has the presumption of innocence until the prosecution can overcome it. And if they don't have sufficient evidence, they can't overcome it. So the defendant walks into the courtroom presumed innocent and hopefully walks out innocent as well.
And so what is the one piece of advice that you would give a person facing a DUI charge?
One piece of advice. Wow. So yeah, that's a tough question, Sharon. But I think what I would say is, I don't want to say one piece of advice, but just if I had to say off the top of my head for purposes of this session, if you have a DUI pending, at a minimum, get a consultation with an attorney. At a minimum, even if you decide you don't want to hire the attorney, even if you decide you want to take a guilty plea and accept the prosecution's offer, even if you decide you want to go with a public defender, get a qualified attorney to review the facts of your case with you and tell you what you're facing. We talked a lot this session about strategy and about challenging evidence, right? Most of those challenges are time sensitive, and the time starts to run on most of those things the day you're arrested, not the day you bond out, not the day you go to arraignment, the day that you're arrested. And so if you're not diligent about getting somebody to review the facts of your case in a timely manner, you probably are going to miss out on some good legal challenges that you could make. But while we're on that, let me say this too. Make sure that the person that you go to is experienced with DUI law, okay? And the reason I say that is I handle general criminal law as well, and I can tell you that DUI law is much more technical. There are a lot of challenges available to DUI defendants that are not always available to general criminal cases. And so if you get somebody that's a general practitioner, they may or may not be aware of all of those. So you want somebody who's skilled in DUI law. And like I said, even if you decide, you know what, I heard what you had to say, I'm going to just go it alone, I can totally understand and respect that, but at least know sort of what the framework of what you're dealing with is. So I think that would be my advice. At least get a consultation, even if you don't hire a lawyer.
I think that's really good advice.
Well, thank you, Sharon.
Well, do you have any other little tidbits before we close?
Gosh, I feel like I've said so much, but probably not anything at all, right?
Well, why don't we do this? There might be some people who are watching right now or who come across this Google Hangout on YouTube or on Google Plus who have had a DUI. How do they get in contact with you?
So there are a couple ways you can reach me. You can call my office, Phillips Law Group, at 404-761-6800, 404-761-6800. You can also email me at Ebony, EBONY, .Phillips, PHILLIPS, at phillipslawatlanta.com. Phillips Law Group is also on Facebook and LinkedIn if you prefer to send me a message that way. We do check those regularly. And if it turns out that it's a situation that we're not able to assist you with, because like I said, I do handle other types of law, we do have a pretty strong network, and so we could probably get you to the right person that you need to speak with. So even if you don't have a DUI, but you have some other legal matter that you need to talk to somebody about, you're not sure even what kind of lawyer you need, we can certainly help out with that as well.
Wonderful. Well, this has been a very educational session. I learned a lot, and like you, I'm not a drinker, so I don't anticipate getting a DUI, but you know, if that happens, I certainly am prepared with some information that I didn't know. I just thank you so much for taking the time out of your busy
Well, thank you,
schedule
Sharon.
today.
Appreciate it.
And, I hope the viewers find this as interesting and useful as I did.
Thank you, Sharon.
All right. Well, have a good afternoon.